Property, week 6. So today we're talking about gifts, chapter 5 in the text. Types of gifts, legal requirements for transferring gifts, and some of the historic issues that have created these requirements. And also some of the solutions to the stringent nature or the strict nature of the requirements. So, there isn't that much difference between a sale of goods contract and gifts. The sale of goods requires an offer and acceptance and consideration, so evidence of something flowing between the two parties, or evidence to be legally bound by the offer and acceptance. In an inter vivos gift, which is basically any gift that happens during your lifetime, there requires an intention, similar to an offer, an acceptance, and also delivery, and this is evidence of the intention. And that equals a perfect gift, and this is well established and is mostly the subject of what we're talking today, is how to make this happen in instances where it's not a perfect gift. Are there other ways to transfer the property? So types of gift, inter vivos gifts happen during your lifetime. Mortis causa gifts happen when you are near death, and the person that you're giving it to doesn't get absolute title. Their title is subject to you dying, and then their title becomes absolute against the donor's executor, not under the donor's executor, as would be the case with a testamentary gift, which is gifting something to someone in your will. So, legal requirements for inter vivos gifts. First, there's intention, and this is generally easy to provide. You can say it or write it, it doesn't really matter. But it's, of course, best to have evidence of it. And the best way to prove your intention is to deliver the gift. Acceptance is just as easy as saying yes. And delivery, this is more challenging, especially when it comes to intangible gifts, or gifts that are already in the house of the receiver. And this is the subject of the cases we're looking at. Inter vivo gifts can also be transferred with equitable solutions to the transfer, such as a deed or through trusts. So policies underlying the legal requirements are to protect donors against fraudulent claims and to protect the donee against challenges to their received gifts, so that people can't go and walk around and saying, oh, that person gave me that necklace, even though it's in their house and I don't have it on me. And to protect the donee against challenges of the received gift. So if you have a gift that's been delivered to you, so the other person can't say, oh, I never gave that to you. So there's clear evidence of intention with regards to delivery. The case we looked at mostly was Cochrane and Moore from 1890. The facts are that Moore was the driver of a horse, and he was given a quarter of the horse, or a quarter share in the horse, after driving particularly well in Paris. And that was in June. In July, Benson, the owner of the horse, that gifted him a quarter of the horse, borrows a lot of money from a third party named Cochrane. Later, Benson pays Cochrane, and the horse is included in the schedule of payment. Cochrane brings up the fact that Moore owns a quarter of the horse, but then says, oh, it'll be all right. And there's also the fact that Benson sent a letter to Yates where he mentions Moore owning a quarter of the horse. So, the trial judge decides that where a gift of a chattel capable of delivery is made verbally by a donor to be done and is assented to by the donee, and that assent is communicated to the donor, then there is a perfect gift. And this trial judge basically altered the common law, or tried to anyway, which was established in Irons and Smallpiece. So Irons and Smallpiece, in there they stated that you can transfer a gift by deed, by an instrument of gift, i.e. a testamentary will, or by actual delivery. And this could be with regards to inter vivos or mortis causa gifts. And this is very clear. It's like the Arbery Delmiri case, whereby the finder holds rights above all others, with the exception of the original owner. And on appeal, the judges decided that the Irons and Small Peace rule should stand. And that is the rule that we should use to determine whether there is a perfect gift. Now, they brought up the interesting questions of how exactly do you deliver a quarter horse? And also, does the letter by Benson to Yates constitute a constructive delivery? They don't actually answer these questions, though. They prefer to rely on a constructive trust. So, because of the historical implications of going against the delivery notion of Irons and Small Peace, they didn't exactly want to deal with it. They just wanted to say delivery is delivery. In this case, there was no delivery. However, there was a constructive trust, or they did construct a trust. If they went against Irons and Small Peace, they would essentially be dismantling notions regarding deeds and contracts, or consideration in contracts, and a long history of the common law. So historically, there wasn't a big difference between land and personal property. There were no executory contracts. There was seisin, where you literally had to deliver everything. So if you were providing, something for something, you delivered it and you received the thing in exchange. And it happened in the moment. So with regards to real property, it was called livery, and you could give a clump of land to symbolize or construct the giving of land. Eventually, it was gradually accepted that you could give a deed with a seal, and your seal was your intention. And this allowed for kind of the time period to separate between the act of giving and receiving the other promise. And then in the Tudor period, the channeling function of consideration was created. So having evidence of the offer and acceptance in a contract. So the, finding that you don't need to deliver something in order to have it be a gift is, with the exception of a deed, obviously, fine, but with the exception of delivery and relying only on an oral promise and acceptance, would effectively kind of dismantle a great history of the common law. Great in the sense that it's long, and with reason as well. So the solution in Cochrane and Moore was a constructive trust. Here's the history of constructive trusts. So that's a hypothetical. The king gives A tract of land in exchange for cups. A would give it to B in exchange for knight service by B. But there isn't any way to pass property when you die. So when B dies, it would go back to A. Then they created primogeniture. And it could go to B's eldest son as long as B's son paid a full year of production to A. So what would happen if B goes off on knight service and dies, but his child is only 11? So what would happen is B would give the land to his brother on behalf of his son in case he died. And it was lawful. But when B died, his brother could just keep the land. There was no concept of a trust or holding land for someone else's benefit. Then equity came into the situation and said, we will make sure you act on behalf of your brother's son. And so what they created was the idea that the settler is B, the trustee is B's brother, and the beneficiary is B's son. In the Cochrane-Moore case, the settler is Benson, who originally had the quarter horse that he gave away. The trustee is Cochrane. He gave the quarter horse to Cochrane for the benefit of more. So the express trust can be in writing or words, and when Cochrane said, what about the quarter horse? Oh, it's all right. They were effectively creating a trust. So, the requirement for a gift is much more stringent than for the creation of a trust. All that's required for a trust is intention to create a trust, the subject matter of the trust, and the objects of the trust. So when Cochrane acknowledged the quarter horse and said it's okay, they created a trust. And Moore could, the quarter horse is now for his benefit in the hands of Cochrane. And it's easy to get the quarter horse back that way. So, I guess to summarize that case, the trial judge changed the rule in Irons and Small Piece, but that was rejected by the court. And rather than dealing with the intricate issues of how do you deliver intangible goods, or is a letter recognizing that you gave it to someone a constructive delivery, they preferred to just go the easy route and construct a trust, because the evidence was there to construct a trust, and give the quarter horse to Moore. I suppose it is possible, they could have easily just said, delivery is delivery is delivery. There wasn't any. Until he delivers it, he hasn't actually given it to you, and it's still his to give to someone else. Which is often the case with birthday presents, for example. You buy something for someone and maybe you forget or get too busy and you haven't given it to them, and maybe even told them that you were going to get them the gift. And then you happen to run into money troubles and you need to sell the gift in order to pay for your money troubles. So anyway, there was enough evidence to construct a trust, and they did. In Watt versus Watt Estate, for more than 20 years, the plaintiff provided unpaid assistance while renting a marina. Over 4 years, the plaintiff and the defendant built a boat together. The boat was registered in the defendant's name. They both had keys, and the plaintiff's family used it frequently. Later, out of concern for being sued, the defendant put the boat in both their names and said they were joint owners. Whenever he gave a document to the plaintiff and then subsequently died. The decision in this case was that it was not a valid gift. The delivery of keys does not constitute a delivery, and the fact that the defendant kept his own keys means that it wasn't a perfect gift. However, it does constitute an executed trust, and this gave the plaintiff the right to a half ownership in the boat.